Let me speak standing up. I'm a little more comfortable doing that. Now, to follow up on Professor Baker's lecture, which I thought was very good, you're not going to find too many differences, I think, in our views. But my role is to push it a little deeper and a little farther, and to focus in particular on the question of entity liability, that is to say, corporate criminal liability in a technical sense, holding the corporate entity criminally responsible as opposed to some other structure. And I've subtitled my, I debated, my first subtitle was Cassandra's Curse, but I abandoned that because many of us perhaps predicted this difficult outcome that we now face, and instead entitled it An Abolitionary View, which is intended to connote that I'm an abolitionist when it comes to corporate criminal liability, and I have been for a long time. And at least since 1991, when I delivered a speech and a paper on the very eve of the effective date of the corporate criminal sentencing guidelines, and in that paper not only essentially outlined the same points I'm going to give you today, which have become, I might add, a little bit less controversial since, that's the Cassandra part, but that included a prediction that the corporate criminal sentencing guidelines, as they were now, or rather the organizational criminal sentencing guidelines, were going to lead to what I called in that paper a shadow bureaucracy. That is to say, a new regulatory agency without an authorizing statute, without any accountability to anybody. And that's what's really happened over the years by the application of the organizational sentencing guidelines that in fact were adopted in 1991. I hasten to add that, like a lot of abolitionists, I came to abolitionism through pragmatism, because my first contact with this was as counsel to the Sentencing Commission, where I came down to actually work on corporate guidelines and developed a set of guidelines that were published for comment in 1988. Those were derailed by an alternative set of guidelines that had been, and you'll never guess who proposed them, it was the Department of Justice, then under Dick Thornburgh. And these guidelines were the one that led to this, what I would call a very interventionist product that we now live with. Now, so I think, let me go to my next slide. I hope this thing works. Okay. The perils of expediency. Corporate criminal liability, as I said, I agree somewhat with Professor Baker, but in the United States, it was really an expedient. In the mid-19th century, there was no fully developed public law enforcement system in the United States. And so in these early cases, what you see is the courts sort of using criminal liability as a proxy for public enforcement. That's what might be called for in some of these instances, but since 1850 or thereabouts, we have a very different public civil law enforcement system than we did then. And so corporate criminal liability, among other things, is obsolete. Now, what's wrong with it, or what's in a name, as one of my slides says? Well, first point is, I think that corporate criminal liability causes economic harm. I'll give you more detail on that, but the bottom line is this. There's a virtual unanimity, let's say broad agreement, in economic analysts that corporate criminal liability is a bad thing because it impairs, it diverts the advantages of the business firm that might be harnessed in favor of law enforcement, but in fact are being administratively directed under something like a compliance plan regime. And just think about it. The notion of the federal organizational sentencing guidelines is that all corporations are big bureaucracies, or really should be operated like big bureaucracies. But they're not. Business firms are as diverse as individuals. Many of them operate well with a sort of bureaucratic approach. Others do not. So in effect, what this regime does is it forces corporations into a bureaucratic method of controlling their own agents, which may not be best for them. They may better control them through shared ethical values or through encouraging in the individual a sense of responsibility and reciprocal trust. I mean, there are some commentators in recent years who have developed these points, essentially arguing that the corporate compliance program world encourages unethical behavior, basically, inside of corporations and among its members. Second main point, prosecutorial overreaching. Well, enough has been said about that. I don't think I need to develop it any further. I mean, what you see as a result of the Holder-Thompson memo evolution is that the prosecutors are using the threat of corporate criminal liability to extract various kinds of concessions, such as waiving the attorney-client privilege, and you'll hear a lot more about that in detail. My main point in referring to it is that, and it sort of follows from the first point, which is that if you're going to pick somebody to be a new corporate management regulator, I seriously doubt that we would pick prosecutors. They're not trained for it, they're not qualified for it, and their incentives are really bad for it. Because prosecutors are not like regulators, right? Regulators, presumably, are oriented toward trying to develop efficient compliance with law, right? They actually want law to be observed. Prosecutors, on the other hand, and I don't think this is a debatable point, they don't want law to be observed, right? Because they get rewarded on the number and colorfulness of the scalps they hang on their walls, right? So I think you've got a serious incentive problem and a serious qualification problem. And third, and most important to me, and it echoes what's been said by Professor Baker and many others, what I call a metastatic corruption of the moral foundations, that it's just not possible, it turns out, to say, well, corporate criminal liability is kind of an exception, and we'll just forget about mens rea and moral responsibility in that context, and we'll be able to protect the core. And my main argument is you can't protect the core, because this disease is contagious. It's a tumor that's metastatic, and it's invading the rest of the body. And there's increasing evidence of that fact in recent developments. Now, let me go to my next slide. What's in a name? This is where I want to push the point a little deeper. And by the way, for those interested, I'll put up a citations list to go along, keyed to my slides, so that you don't have to worry about taking down anything. Let me push a point a little deeper that Professor Baker made. Sutherland invented both white-collar crime and corporate crime, basically. Sutherland and his disciples. Again, his book, White-Collar Crime, 1949, it reported on enforcement actions. And remember, this is in the maximal liability federal system is what he focused on. Only 84% of those actions were, in fact, civil or administrative. Sutherland argued, as mentioned, well, they should be crimes, and his arguments are, to our eyes today, and to lawyers' eyes even at the time, preposterous, right? He was just basically trying to change the definition of crime. Similarly, even much later, one of his disciples, Marshall Clenard, in the 1970s got a grant from guess who? The Department of Justice, to conduct a empirical study of corporate violations that was initially published under the title Illegal Corporate Behavior by the Department of Justice. LEAA, actually, is where the money came from. And then Clenard republished it in 1980 as a commercial book under the different title, Corporate Crime, right? In that book, 97% of the enforcement actions reported were administrative or civil, not criminal, even under the expansive federal definition. So you might ask what's going on here, and actually I think Jerome Hall another figure mentioned by John Baker, got it very correctly in his book in 1960 on the general theory of criminal law. He points out where the so-called public welfare offense and the general notion of strict liability in crime came from. And what it came from was mid-19th century, initially French theorists who were essentially they call themselves positivists, but we would recognize their theory today as determinism. And what that basically means is they didn't view criminal behavior as resulting from the human will at all. It was simply the product of social influences and what Sutherland called differential association, all of this business. But notice the implications. Again, this idea is not a new idea. It's been debated in criminal law. And so their agenda here was nothing short of changing our whole concept of what crime is, and not just for corporations and their officers. There's really a broader agenda. It's to essentially deny free will, this is what I have on the slide, and replace it with determinism. Now, this is sort of the Clockwork Orange notion, right, of criminal responsibility. And it is, in fact, contagious. Now, let me go to the next slide. Some of this replicates what Professor Baker discussed, and so I'm not going to belabor it very much, but there is, in addition to the federal system of respondeat superior, what I would call strict liability twice removed, right? Because the people who really feel the effect of sanctions are, in fact, the stockholders, the customers, the employee, the innocent, all of the innocents basically absorb corporate sanctions. Whereas the model penal code is perhaps, in effect, it's really more of the imputation of the fault of, at least the residual form is under the superior agent, what's called the high managerial agent or superior agent rule, is like imputing to the corporation a crime of an individual. But there's another theory abroad, which is really, in a way, what is reflected in the current organizational guidelines, which is what you might call the corporate ethos theory. And that's the notion that, well, even though we can't locate a guilty individual, it's all of this, ethos swirling around, and we can decide whether or not that ethos is or isn't culpable. Now, which leads to part two. All of this thinking goes back to a social and political and I guess moral philosopher, self-characterized, by the name of Peter French, who came up with this idea of the corporate internal decision structure. And that's this notion that all this ethos and plus explicit policies and differential association, all that kind of goes into an amalgam. And we can come up with this corporate internal decision structure. Well, the problem with that, as I pointed out in a 1997 paper, which I'll put on my site list, is what it does, it's more profound than ever, because like the basic impetus of determinism, it denies that human beings are any different, right? And in fact, it's not just corporations, as I put up there. That was actually my example, is that under this theory, you can't morally distinguish a corporation from a toaster. And therefore, you can't even distinguish a human being from a toaster. Because a toaster has a feedback loop, it gathers information, it responds to stimuli, or a computer program, or any of a number of other things, right? It invests moral competence in things that are essentially innate objects. And after all, that's what a corporation really is. It's just an organizational technology. That's all it is, right? So it's not really different from a toaster. But I think there's a difference between a toaster and a human being insofar as criminal responsibility goes, and that's what's being denied by this group of theories. Now, there's another variant of this called expressive retribution, and this is this notion of, well, the public demands something. The public demands responses to things. even if there is no even if there's no fault of anybody, not even under the CID concept, right? Well, this also is not at all consistent with the traditional basis for criminal liability. Now, again, I've mentioned recent developments. I think I'm running out of time here. Here's my analysis. It's hard to make a case for criminal sanctions as opposed to, say, civil strict liability from the standpoint of economics. There's several reasons why, which fall over into the second point. One is, it's a complex problem. You have individuals, you have entities, there's a multiple sanctioning system, there are also possibly multiple functions that the corporation is supposed to carry out. Is it trying to prevent, which most of us say is the more important function, or is it acting as an impressed police force? That produces different types of incentives within the corporate structure. Now, my main argument on this is that in addition to the fact that we need to know a lot about how to operate this, we also, the theory requires an enormous amount of good information about such things as what actually is very precisely the social harm of the particular offense in question, which we don't know, really. And secondly, where is that trade-off between prevention and detection and fessing up and all of that sort of thing? And we don't know that either. In order to implement a regime like is under the current corporate guidelines, you've got to know both. And this is part of the argument for why a strict liability civil sanction at uncertainty discounted, and when we talk about what that means, or uncertainty multiplied, roughly compensatory levels, is the preferred system from economics, because what it does is it translates a law enforcement objective into a business objective and thereby harnesses what the corporations are good at, which is operating on business management problems. Now, am I out of time? I'm way out of time, right? Okay, let me just skip over. I've mentioned this before. Here's my prescription. Get rid of it. Right? Ignore it, it'll go away, because it's only in your imagination to start with. Now, what to do about white collar? Similar suggestion. And I wanted to get to this. What can judges do? After all, you're all judges, right? And I think that the point is, and we can develop this further, but there's certainly, even in the federal system, there's a lot of nibbling around the edges that can be done and is being done by your colleagues. There are efforts to more strictly interpret the scope of employment and benefit of the firm criteria. There's also something you can easily do, which is to make sure that you hold prosecutors to a high standard. And that, I think, can help a lot. Now, but ultimately, my first point up there is this is largely a judge-made doctrine. It really is. There are a few federal statutes that require it, and again, as mentioned, Model Penal Code has provisions for it, and a lot of state laws, but there's not much in the statute law that actually requires this. End of program. Sorry, I'm over here. Not that far.